There is a house in New Orleans they call upon the rising sun. All right, we're going to go through about 33 questions and answers to help people understand status, all right? And in equity, of course, we don't use statutes, codes, city ordinances, rules, regulations. We use sound doctrines and principles. However, this is a fun little exercise that you can do with your, or with the government that be under this current time and administration, okay? There's a great deal of research that has went into this. I did not actually put this together. I have been researching what these people have been saying, and thus far have not been able to conclusively prove otherwise as to what they are saying. So without any further ado, we're going to try and get through all 33 of these in one setting, so people have one fluent video that they can reflect upon. And so let's get started. If the Declaration of Independence says that all just power of government derive only from our consent, and we do not consent to anything, then aren't the criminal then aren't the criminal laws the only thing that can be enforced against non-consenting parties, since they don't require our consent to enforce? First of all, criminal talk, the criminal word criminal, I should say, applies to statutory civil Roman law. Okay, that's what criminal is. Everything else would be a trespass causing a man harm by way of theft or taking or whatever. Okay, that's the common law side of it. Criminal activity would be in the civil law side of it. Okay. And the answer to that question is yes, all right? The only thing that applies is that you keep your hands, your feet to yourself. You don't touch what doesn't belong to you, and you don't take from other people what is not yours, okay? And you honor your contracts and you fulfill your obligations. That's it. That's all that is expected of man in the grand scheme of things, okay? Question number 2. Certainly, if we do not want protection or benefits, privileges, and immunities of being a statutory civil citizen domiciled on federal territory, then there ought to be a way to abandon it and the obligation to pay for it. What they're talking about here is taxes and the presumption and assumption that you are a member of Washington, D.C., the District of Columbia, the District of Criminals, and that you're part of their statutory scheme residing in one of their territories, okay? At least temporarily, right? So, absolutely, one can be protected by the common law without being a person, okay, under the civil law. If one has a right to not contract and not associate, then that right begins with the right to not procure any civil statutory status under what the U.S. Supreme Court calls the social compact. Now, the U.S. Supreme Court is telling you that what in fact is happening is they are presuming and assuming that you are a U.S. citizen, that you are domiciled in a federal zone, federal territory under military occupation, and there's this invisible blind adhesion contract called a social compact that you're part of, whereas you have to pay like you would pay the mafia for protection, okay? All compacts are contracts. Yes, that doesn't make such a person lawless because they are still subject to the common law, which hasn't been repealed, okay? The very fundamental principles of this nation are founded upon common law, sound doctrines and principles, and a plethora of maxims of law. If the word permanent, okay, and we find this word, this defining of this word is in Title 8, okay? And they're talking about your permanent residence, your permanent domicile. If you're an inhabitant, these words are very dangerous, and they have a prolific meaning within their society to the district of criminals, okay? If the word permanent in the phrase permanent allegiance is in fact conditioned on our consent and is therefore technically not permanent, all right, as revealed in Title 8 USC subsection 1101A31, can't we revoke it either temporarily or conditionally as long as we specify the conditions in advance or the specific laws we have it for and those we don't? The answer to that question is yes. All that is required is to notice the government that you don't consent. Everything beyond that point becomes a tort under the common law. It becomes a trespass, all right? If they encroach upon you and your unalienable rights after you've put them on notice, that is a trespass causing you harm, which would lead to a tort at the common law. If the separation of powers does not permit federal civil jurisdiction within states, how could the statutory status of citizen carry any federal obligation whatsoever for those domiciled within a constitutional state and outside of the federal territory? The answer to that is they don't. All right, ladies and gentlemen, you really have to read between the lines, understand what they're talking about. There are two different forms of government, okay? And we have always been guaranteed a Republican form of government. Should you opt to keep it, should you opt to exercise your right to defend it, protect it, and uphold it, all right? That's what Benjamin Franklin said. Now, it was very interesting the other day. I posted a video about the Founding Fathers, thinking that everything was based on Christianity, and I got to this video from Brian Parker. And some of the stuff he shares, I really enjoy, and then other stuff I think it's a little far-fetched. But with anything, we want to receive things with an open mind, be outside the box, and be able to analyze it, and not so quickly pass a judgment on it until we can do a little further investigation. But he shared this video with me about the Founding Fathers all being Masons, most of which agreeing with the principles in the Bible, but not what they would call fables or fairy tales in the Bible, talking about the sound doctrines and principles that were in the Bible, but not necessarily, a virgin being able to conceive child, and other things. And so that it struck me very oddly, because a lot of the literature I read may be heavily biased with absolutely no supporting evidence or facts compared to the video that Brian Parker shared with me the other night. And I haven't been able to delve into the research yet, but it was very interesting talking about how the Founding Fathers actually when they talked about religion, it wasn't necessarily in the context of Christianity, which was interesting to me. And then further on, it went on to exclaim how Thomas Paine actually wrote a number of books to the contrary, and that he was in fact good friends with Benjamin Franklin, George Washington, so on and so forth. So I'm going to have to reevaluate my take on some of the literature that I've read. And that's a good thing to do. Number 4, if the separation of power does not permit federal civil jurisdiction within states, how could the statutory status of citizen carry any federal obligation whatsoever for those domiciled within a constitutional state and outside of a federal territory? The short answer to that is they don't. Federal civil and common law has no bearing upon anyone other than public officers. Criminal law has no bearing upon anyone other than public officers within a constitutional state. Those officers, in turn, come under federal civil law by virtue of the domicile of the procedure 17. Otherwise, Rule 17 forbids quoting federal civil law against a state citizen domiciled outside of the federal territory. Number 5. If domicile is what imparts the force of law to civil statutes per Federal Rules of Civil Procedure 17, and we don't have a domicile on federal territory, so that's Washington, D.C., Guam, Puerto Rico, the outer minor-lying islands, or Mariana Islands, then how could we in turn have any civil status under the laws of Congress, including that of citizen or resident? Okay? Well, to put that quite frankly for you, you can't. The only reason people believe otherwise is because of propaganda and untrustworthy politicians of the government designed to destroy the separation of powers that is the foundation of the Constitution. Remember, there are two forms of government. There was the federal and then there was the state. And the state wielding far greater power. And if you don't believe me, you just go read Article 1, Section 9. The powers not delegated to the government are retained by we the people. All right, because we the people are the first branch of government. We created government to best suit our needs in protecting our unalienable rights. Isn't a national non-resident just someone who refuses to be a customer of specific services offered by government using the Civil Statutory Code franchises, Title 28, 3002, 15A, B, and C as well? Why can't I choose to be a non-resident for specific franchises or interactions because I don't consent to procure the product or services? The answer to that is yes. You can opt out of specific franchises by changing your status under each franchise. The DMV, the Social Security Administration, vital records, you name it, you can alter it. They all act independently or the unconstitutional conditions doctrine is violated. Question number 7. If the national and citizen of the United States at birth under Title 8 U.S.C. subsection 1401 involves two components being national and citizen, why can't we just abandon the citizen aspect of it, for specific transactions, by withdrawing consent and allegiance for those transactions or relationships? Wouldn't we do that by simply changing our domicile to be outside of federal territory, since civil status is tied to domicile? The answer to that question is yes. You own yourself and your property. That right of ownership includes the right to exclude all others, including governments, from using or benefiting from the use of your property, including your signature, your DNA, your RNA, your fecal matter, your urine, whatever the fuck it may be. It is yours, okay? Under Title 26 CFR, subsection 301.7701-5, domestic, foreign, resident, and non-resident person. A foreign corporation engaged in trade or business within the United States is referred to in the regulations in this chapter as a resident foreign corporation. And a foreign corporation not engaged in trade or business within the United States as a non-resident foreign corporation, a partnership engaged in trade or business within the United States is referred to in the regulations in this chapter as a resident partnership, and a partnership not engaged in trade or business within the United States. As a non-resident partnership, whether a partnership is to be regarded as resident or non-resident is not determined by the nationality or residence of its members or by the place in which it was created or organized. Okay? Question number 8. How can the government claim we have an obligation to pay for protection? Okay, it's nothing more than RICO racketeering mafia-style protection, right? We don't want if it is a maximum of the common law that we may refuse to accept a benefit. Remember, he who accepts the benefit also accepts the burdens that come with it. They don't have the authority to demand that we buy or pay for anything that we don't want. It's a crime to claim otherwise in violation of the Fifth Amendment Takings Clause, extortion under Title 18 U.S.C. subsection 872, mailing threatening communications if they try to collect it, Title 18 USC subsection 876, and racketeering under Title 18 USC Chapter 95. Now again, what I just read to you applies to them. It doesn't apply to you. So when we're using their codes to persecute them, that's because Congress has the power to create laws that keep control over government, just as the legislator does. Congress and legislators do not have the authority to pass laws that affect us, we the people, the sovereigns of the nation, all right? The ones who owe an allegiance to the state prior to 1781. From 1776 to 1781, if you are a state national, part of the Union of States, owing an allegiance to the state, right? You are protected by the organic Constitution. And this is stuff they're not teaching you in school. Number 9. If I'm not allowed to abandon the civil protection of Caesar and the obligation to pay for it, and I am forced to obey Caesar's social compact, remember the blind adhesion contract under the presumption and assumption that you are part of a federal fucking territory, and franchises called the civil law, civil Roman law, Caesar's law, and I am forced to be privileged and a civil subject, isn't there, the answer to that, an unconstitutional taking without compensation of all public rights attached to the statutory status of citizen if we do not consent to the status? Yes. And involuntary servitude? Yes. So isn't it involuntary servitude? Isn't it a crime if we're forced to engage in this social compact against our will, against our consent, after we've provided notice to them that we do not wish to participate in the RICO racketeering Ponzi fucking scheme for protection, right? Yes, it is. And so what does it classify as? Any unconstitutional taking without compensation of all the public rights attached to the statutory status of citizen if we do not consent to the status. Yes. Involuntary servitude? Yes. Peonage? Yes. Forced slavery? Yes. What if I define what they call protection not as a benefit, but an injury? Now, that's a great question. Who is the customer here? The customer should be the only one who defines what a benefit is and only has to pay for it if he defines it as a benefit. You, the sovereign, are the customer. The customer is always right. A government of delegated powers can have not more powers or sovereignty than the individual private man who make it up and whom it serves. Number 11. The U.S. government claims to have sovereign immunity that allows it to pick and choose which statutes they consent to be subject to. See Alden versus Maine, 527 U.S. 706 in 1999. Under the concept of equal protection and equal treatment, why doesn't every person, or at least every man, have the same sovereign immunity? If the government is one of delegated power, how did they get it without the man who delegated it to them also having it? The answer is yes. Man also have sovereign immunity. Only their own consent and actions can undermine or remove that sovereignty. It's insane and schizophrenic. Schizophrenic, maybe? Schizophrenic? We'll go with schizophrenic. To conclude that a government of delegated powers can have any more sovereignty than the man who made it up or delegated that power. Likewise, it's a violation of maxims of law to conclude that the collective can have any more rights than a single man. Why isn't that same government subject to Foreign Sovereign Immunities Act under Title 28 USC Chapter 97 and suffer a waiver of sovereign immunity in state court when it tries to commercially invade a constitutional state against the consent of specific inhabitants who is protected by the Constitution? They are subject to it. To suggest that they can pass any law that they themselves are not also subject to is, in the context of those protected by the Constitution, amounts to an unconstitutional title of nobility to the United States federal corporation as a legal person. Isn't a statutory citizen just a customer of government services? The answer to that is yes. The services derived by this customer are called privileges and immunities. Those who aren't customers are 1, non-resident, non-persons, and 2, not subject, 3, immune from civil statutory law under Federal Rules of Civil Procedure 17, and 4, protected only by the common law under principles of equity and the Constitution alone. Shouldn't that customer have the same right to not be a customer for specific services, franchises, or titles of code? Isn't the essence of freedom of choice and exclusive control over your own private property and what you consent to buy and pay for? Yes, the main purpose of any government is to protect your exclusive ownership over your private property and the right to deprive anyone and everyone from using or benefiting from the use of your private property. If they won't do that, then there is not government, but just a big corporation employer in which the citizen-government relationship has been replaced by the employer-employee relationship. That's the essence of what ownership is legally defined as: the right to exclude others. If you can exclude everyone but the government and they can exclude you without your consent, then they are the real owner and you are just a public officer, employee, acting as a custodian over what is really government property. Hence, the government is socialist, because socialism is based on government ownership and or control of all property or no private property at all. Isn't it a conspiracy against rights to punish me by withdrawing all government services all at once if I don't consent to everything, every franchise, and every duty arbitrarily imposed against citizens by the government? That's how the current system works. Government refuses to recognize those such as state nationals who are unprivileged and terrorizes them and steals from them because they refuse to waive sovereign immunity and accept the disabilities of being a statutory citizen. Yes, absolutely. Yes, absolutely. Under such a malicious enforcement mechanism, uncoerced consent is literally and rationally impossible. What business other than government as a corporation can lawfully force you and punish you for refusing to be a customer for everything they make, or starve to death and go to jail for not doing so? Isn't this an unconstitutional title of nobility? Other businesses and even I aren't allowed to have the same right against the government and are therefore deprived of equal protection and equal treatment under the law, or under the Constitution instead of statutory law. The answer to that is no. No other business can do that or should be able to do that. And hence, the government has supernatural and superior powers and has established not only a title of nobility, which is heavily forbidden from doing so, but a religion in which taxes become unconstitutional ties to a state-sponsored religion. Civil rulers are gods with supernatural powers. You are the compelled worshiper, and court is the church building. If the First Amendment allows for freedom from compelled association, why do I have to be the same status for every individual interaction with the government? Why can't I, for instance, be the following at the same time? A political but not statutory civilian citizen of the United States under Title 8. You can. A non-resident for every other title of the U.S. Code because I don't want the benefits or protection of the other titles. You can. Under the Uniform Commercial Code, you can be a merchant in relation to every government franchise selling your private property to the government and specifying terms that supersede or replace the government's author. If they can offer franchises, you can defend yourself with anti-franchises under the concept of equal protection. A non-resident non-person for every act of Congress. Yes, domicile outside of federal territory makes one a non-resident and transient foreigner under federal civil law, unless already a public officer lawfully serving in an elected or appointed position within a constitutional state. Question 12.4. No domicile on federal territory or within the statutory United States, and therefore immune from federal civil law under Federal Rules of Civil Procedure 17b. Yes, absolutely. Choice of law rules and criminal identity theft occurs in Rule 17 if Rule 17 is transgressed, and you are made involuntary surety for a public office called citizen, domiciled in what Mark Twain calls the District of Criminals. 12.5. A private person only under the common law with a domicile on private land protected by the Constitution but outside the state, which is a federal corporation. Only those who are public officers have a domicile within the statutory state, and only while on official duty pursuant to Title 4 U.S.C. subsection 72. When off duty, their domicile shifts to outside the statutory state. The answer to that is yes. By refusing to consent to the privileges or benefits of statutory citizenship, you retain your sovereign immunity, retain your constitutionally protected rights, and are victim of a tort of the federal government if the federal government refuses to leave you alone. The right to be left alone, in fact, is the very definition of justice itself, and the purpose of courts is to promote and protect justice. Number 13. Is the citizen in Title 8 of the U.S. Code the same citizen that obligations attach to under Titles 26 and 31? Could Congress have instead created an office and a franchise with the same name of citizen of the United States? Under Title 26, imposed duties upon it and fooled everyone into thinking it is the same citizen as the one in Title 8. Our answer: if it is a usurpation occurring according to the U.S. Supreme Court in Osborne versus Bank of the United States, making a person makes a case, and thus a government which cannot exercise jurisdiction unless an alien or a citizen of another state be a party, makes a party which is neither alien nor citizen, and then claims jurisdiction because it has made a case. If this be true, why not make every citizen a corporation sole, S-O-L-E, and thus bring them all into the courts of the United States, quo minus? Nay, it is still worse, for there is not only an evasion of the Constitution implied in this doctrine, but a positive power to violate it. Suppose every individual of this corporation were citizens of Ohio, or, as applicable to the other cases, were citizens of Georgia. The United States could not give any one of them individually the right to sue a citizen of the same state in the courts of the United States. Then, on what principles could that right be communicated to them in a body? But the question is equally unanswerable if any single member of the corporation is of the same state with the defendant, as has been repeatedly adjudged. That's Osborne versus Bank of U.S., 22 U.S. 738, 1824 was the year of the case. Number 14. If the Bible says that Christians can't consent to anything Caesar does or have contracts with him, Exodus 23, 32 through 33, and Judges 2, 1 through 4, then how could I lawfully have any discretionary status under Caesar's laws, such as statutory citizen? The Bible says I can't have a king above me. Those not domiciled on federal territory and who refuse to accept or consent to any civil status under Caesar's law retain their sovereign and sovereign immunity and therefore are on an equal footing with any and every government. They are neither a subject nor a citizen, but also are not lawless, because they are still subject to the common law, and must be dealt with only as an equal in relation to everyone else, rather than a government slave or subject. See Exodus 23, 32 through 33, and Isaiah 52, 1 through 3, and Judges 2, 1 through 4, on why God forbids Christians to consent to anything government Caesar does, and why this implies that they can't be anything other than an equal and sovereign in relation to Caesar. Number 15. If the Bible says that God bought us for a price and therefore owns us, then by what authority does Caesar claim ownership or the right to extract rent called income tax upon what belongs to God? Where is the money if he charges taxes on the use of property which belong to God? Isn't Caesar therefore simply renting out stolen property and laundering money if he charges taxes on the use of property which belongs to God? The answer to this is yes. He is, according to God, the Holy Bible says that the heaven and the earth belong not to Caesar, but to God. Deuteronomy 10:15, Caesar, on the other hand, falsely claims that he owns everything by divine right, which means he stole the ownership from God. Like Satan, he is a thief. He is renting out stolen property and therefore money laundering in violation of God's law. 4. Statutory versus constitutional citizen. When words lose their meaning or their context which establishes their meaning, people lose their freedom. Confucius, 551 BCE, 479 BCE, Chinese thinker and social philosopher. Statutory citizenship is a civil status that designates a person's domicile, while constitutional citizenship is a political status that designates a person's nationality. Understanding the distinctions between nationality and domicile is absolutely critical. Nationality, number 1.1, is not necessarily consensual or discretionary. For instance, acquiring nationality by birth in a specific place was not a matter of choice, whereas acquiring it by naturalization is. 1.2 is a political status. 1.3 is defined by Congress, which is a political document. 1.4 is synonymous with being a national within statutory laws. 1.5 is associated with a specific country. 1.6 is called a political citizen or a citizen of the United States in a political sense by the courts to distinguish it from a statutory citizen. See Powell, POWE versus United States, 109, F.2D, 147, 1940. 2. Domicile, 2.1. Always require your consent and therefore is discretionary. 2.2 is a civil status. 2.3 is not even addressed in the Constitution. 2.4 is defined by civil statutory law rather than the Constitution. 2.5 is in no way connected with one's nationality. 2.6 is usually connected with the word person, citizen, resident, or inhabitant in statutory law. 2.7 is associated with a specific county and a state rather than a country. 2.8 implies one is a subject of a specific municipal but not national government. Nationality and domicile together determine the political, constitutional, and civil statutory status of a man being respectively. These important distinctions are recognized in Black's Law Dictionary. Nationality, that quality or character which arises from the fact of a person belonging to a nation or state. Nationality determines the political status of the individual, especially with reference to allegiance, while domicile determines his civil statutory status. Nationality arises either by birth or by naturalization. Black's Law Dictionary, 6th edition, page 1990, page 1025. President Barack Obama affirmed our assertion that there are two components to your citizenship status at the end of his State of the Union address given on 2/12/2013. The U.S. Supreme Court also confirmed the above when they held the following. Note the key phrase, political jurisdiction, which is not the same as legislative statutory jurisdiction. One can have a political status of citizen under the Constitution while not being a citizen under federal statutory law because not domiciled on federal territory. To have the status of citizen under federal statutory law, one must have a domicile on federal territory, subject to the jurisdiction thereof, but completely subject to their plural, not singular meaning states of the Union political jurisdiction and owing them the State of the Union direct and immediate allegiance. Okay, and that's U.S. versus Wong Kim Ark, 169 U.S. 649, 18 S period CT period 456, 42 L period ED 890, 1898 is when this case was established, and claimed to be protected. He is under the bounds of allegiance to the country of his residence. Remember, your individual state is a country, in fact, and if he breaks them, incurs the same penalties, he owes the same obedience to the civil laws. That is Feng Yu Ting versus United States, 149 U.S. 698, 1893. Noticed in the last quote above that they referred to a foreign national born in another country as a citizen. This is the real citizen, a domiciled foreign national that judges and even tax withholding documents are really talking about, rather than the national described in the Constitution. Domicile and not nationality is what imputes a civil status under the tax code and a liability for tax. Tax liability is a civil liability that attaches to civil statutory law, which in turn attaches to the person through their choice of domicile. When you choose a domicile, you elect or nominate a protector, which in turn gives rise to an obligation to pay for the civil protection demanded. The method of providing that protection is the civil laws of the municipal, as in county jurisdiction, that you choose to domicile within. Domicile, a person's legal home, that place where a man has his true, fixed, and permanent home and principal establishment, and to which, when he is absent, he has the intention of returning. Smith versus Smith, 206 PA, Super 310, 213, A period 2D period 994 period. Generally, physical presence within a state and the intention to make it one's home are the requisites of establishing a domicile therein. The permanent residence of a person or the place to which he intends to return, even though he may actually reside elsewhere. A person may have more than one residence, but only one domicile. The legal domicile of a person is important since it, rather than the actual residence, often controls the jurisdiction of the taxing authorities and determines where a person may exercise the privilege of voting and other legal rights and privileges. Black's Law Dictionary, 6th edition, page 485. Later versions of Black's Law Dictionary attempt to cloud this important distinction between nationality and domicile in order to unlawfully and unconstitutionally expand federal power into the states of the Union and to give federal judges unnecessary and unwarranted discretion to kidnap people into their jurisdiction using false presumptions. They do this by trying to make you believe that domicile and nationality are equivalent or synonymous, when they are emphatically not. Here is an example. Nationality, the relationship between a citizen of a nation and the nation itself, customarily involving allegiance by the citizen and protection by the state. Membership in a nation, this term is often used synonymous with citizenship. Black's Law Dictionary, 8th edition, 2004. We established later in section 14.14 that federal courts regard the term citizenship as equivalent to domicile, meaning domicile on federal territory. The word citizen and citizenship, however, usually include the idea of domicile Delaware L. and W. R. Co. versus Petrowski, C. A. N. Y. 250 F. 554, 557. Black's Law Dictionary, 4th edition, page 310. Hence, the term citizenship is being stealthily used by government officials as a magic word that allows them to hide their presumptions about your status. Sometimes they use it to mean nationality, and sometimes they use it to mean domicile. The use of the word citizenship should therefore be avoided when dealing with the government because its meaning is unclear and leaves too much discretion to judges and prosecutors. In other words, it's vague and ambiguous and loosely defined. When someone from any government uses the word citizenship, you should 1. Tell them not to use the word and instead to use nationality or domicile. And 2. Ask them whether they mean nationality or domicile. Ask them which political subdivision they imply a domicile within, federal territory or constitutional state of the Union. A failure to either understand or apply the above concepts can literally mean the difference between being a government pet in a legal cage called a franchise and being a free and sovereign man or woman. 4.1. Context is everything in the field of citizenship. Citizenship terms are defined by the context in which they are used. There are 2 contexts, statutory and constitutional. Citizenship of the United States is defined by the 14th Amendment and federal statutes, but the requirements for citizenship of a state generally depend not upon definitions, but the constitutional or statutory context in which the term is used. Ryswick versus Davis, 19 MD 8293, 1862 was the year of the case, and Halliday versus Board of Directors of the University of Cincinnati, 162 Ohio ST 290, 293, 123, N E 2D3. This case was held in 1954, and authorities therein cited. Boom, boom, boom. Yep, it's going to be a 2-part video. Good gravy. Yep, it's going to be a 2-part video, ladies and gentlemen. My apologies for that. This is going to get pretty lengthy into talking about status, constitutional status versus civil statutory status. I'll make this maybe a 2 or 3-part video at this point. It's going to get a little more lengthy, and then we'll get back into the questions again. There's 31 of them altogether. It's very good with the answers that go with it and the material that supports it. To help you guys understand what you guys are doing. So, Keith, what's up, brother? 39 CFR subsection 955.19, notice of hearing. Amen, brother. All right, we'll be back with you a little bit later. I'm going to wet my whistle and smoke a cigarette.